political reporter Ziyanda Ngcobo live for you at the court. She joins us now. Ziyanda, good afternoon to you. A long day of argument so far. How would you sum up the main points?
Well, Stephen, I can tell you that the first part of the proceedings today, we saw, of course, Arthur Fraser, the National Commissioner, arriving here after being subpoenaed by the National Prosecuting Authorities in the hopes that they would share the medical records of the former president to justify his absence in court today. You'll recall, Stephen, that initially the former president wanted to physically be here when this special plea was heard in the hopes that he'd also be able to lead oral evidence against Billy Downer. His lawyers, that of the former president, that is Stephen Dalimpo, for arguing why then Billy Downer should be stripped of his prosecutorial title. In the afternoon, Stephen, another interesting argument emerged, led by Thabani Masuku, who was basically saying that the fact that Billy Downer joined the DA's application for the review of the decision to set aside the reinstatement of charges against the former president, there were questions raised by Masuku as to why then he didn't do that internally through the NPA's ethics office. Of course, Judge Bidkun questioning why this wasn't a part of their papers, and someone who will be able to take us through the nitty-gritties of what exactly that argument was about, Mpumelelo Zikalala, to say, well, there's an ethics office within the NPA, why join the DA's application? Does this argument have a leg to stand on, in your view?
It would have had a leg to stand on if it was raised on the papers. Just remember the purpose of drafting these affidavits. You can't raise evidence from the bar, which is from the desk while you're arguing. All the information must be tabled in affidavit so that it is able to be responded to. If you raise it at the bar, the other party, your opponents, don't have an opportunity to adduce evidence which will dispute what you are saying. It would have been a very valid point if it was contained in the affidavit, because it basically means what authority did you rely on as Advocate Billy Downer to then say, I'm not going to do the internal processes, I'm going to go to a private institution or private individuals, depose to their affidavit and then say, this is what should happen. It may be that the intention was noble. Again, I put that in inverted commas. However, the procedure in which you have followed in you disclosing that particular information is the one that is flawed, and this is the one in which the former president's team is relying on in terms of saying, your title to prosecute must be removed due to your conduct of saying, I'm so involved in this particular matter. I want this prosecution to occur come hell or high waters, to such an extent that I'm willing to even disclose information which is private to me, disclosed to me in my capacity as a person who's employed in the NPA. The question would be, do you want to set a precedent in which other NPA employees will then say, I'm doing it for the good of the public, of the republic, I'm doing it for the good of making sure that justice is being served? Or do you want an NPA system which is going to say, you have laws, you have a code of conduct that must be followed, let's follow that every time we have an issue within the NPA?
Well, Vim Trengove, who's of course representing Billy Downer, arguing that the argument brought forward by Zuma's lawyers to say that he should have reported Leonard McCarthy's behavior, he had a duty to do so as a prosecutor, that there's no evidence to show that Billy Downer was aware and that there could have been anything that was done about that. But also this issue of Billy Downer crying when he actually heard the spy tapes. In fact, Vim Trengove saying that he cried because he's a man of integrity. In fact, he should even be given an award for actually showing and going up against his own bosses. When you look at the way in which the arguments have been outlined, Vim Trengove saying that there are 135 paragraphs that have been lifted from a previous application. Do you think the arguments by the former president stand a chance at this stage?
In terms of defining the wider interpretation of the title to prosecute, I don't think they've been able to put up a formidable case. This is why I say so. Let's remember you have precedent in terms of the Porret case, which is very descriptive as to how things should be done. And if you have an issue with regards to the conduct of the prosecutor, What's the method in which you're supposed to follow? Again, this lack of saying, what have you done privately? Have you used the courts as the only resource or the only sort of stance of saying, this is where I'm standing, and this is my issue with the information that's been disclosed? Where I'm going with that is here. Did you complain to the NPA? Did you complain to the Legal Practice Council? Is there any other institution that you've complained to with regards to the conduct of the prosecutor? Or are you only raising these issues now at this stage? And if that's the case, what reliance should the court put to your conduct and how you have handled your matter, despite the fact that you have a case law which is not really against you, which does not support your wider interpretation of the charge to prosecute?
Mpumelelo Zikalala, thank you so much. He's our legal